Hello, my name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm, and we're here to talk about eminent domain in the State Road 20 project. And with that being said, we're going to go ahead and get started. Again, my name is Jordan Walker. I'm with the law firm of Seaver Walker Paget. We are a law firm based out of Alpharetta, Georgia. And we are going to be talking about the State Road 20 project. We're going to be talking about eminent domain, and we're going to be talking about what to look for when GDOT needs your property for a road project. We're going to go ahead and get started. Real quick, who we are, what we're doing today. Again, my name is Jordan Walker. Seaver Walker Paget is an eminent domain only, landowner only law firm. This is the only area of law that we practice or have practiced. And our mission as a law firm is to, well, our mission today, rather, is to help educate you on what to do or what happens when the Georgia Department of Transportation needs your property for a road project. And with that being said, sorry, forgive me. With that being said, again, what to do when GDOT needs a road project? We are not with GDOT. We are going to be talking about the project today. We're going to be talking about eminent domain, and we're going to be talking about what you're entitled to under the law in the form of just compensation. The State Road 20 project is it's been going on for several years now. It's the widening of SR 20 from Canton to Cumming. It's a 20-mile length project, and some land acquisition has been going on for several years now. In fact, construction is going on in various parts of the project. It's a pretty large project. As you can see, it's been divided in several segments. Some segments they're acquiring land, and some segments they're constructing. What is eminent domain? Eminent domain is the power of GDOT to acquire your land for a public use. In this case, the SR 20 project. While they can take it, they have to pay for it. And payment comes in the form of just compensation. Just compensation is guaranteed to you by the Fifth Amendment of the United States Constitution, in addition to the Georgia Constitution as well. GDOT has inherent and eminent domain authority, which means they have the ability to acquire land via eminent domain. As a matter of law, they do not need to be delegated this authority, and they can file eminent domain cases. What that effectively means is that GDOT can file a lawsuit against you to get your land, whether you like it or not. Ultimately, your desire to sell the land to them is not going to stop them in and of itself from them being able to acquire that land through the power of eminent domain. When eminent domain is exercised, a condemner files a lawsuit against your property, against you and your property in the county where the property is located to acquire the property via the court. In Georgia, there are specific pre-condemnation and condemnation requirements that GDOT needs to follow as a matter of law. The first requirement, or one of the first requirements that GDOT has to do, is they have to perform an appraisal on the subject property, the property being acquired, and they also have to inspect it. In addition to inspecting it, they need to allow the landowner to have the opportunity to be present during this appraisal inspection. So GDOT will send an appraiser out to your property to look at it, to inspect it for purposes of the appraisal. And as part of that inspection, they have to allow the landowner to be present, or allow the landowner the opportunity to be present, rather. In addition, beyond that, after the appraisal is done, before negotiations, they have to provide an offer to the landowner. And in addition to providing an offer, they need to provide a meaningful summary of the appraisal, which forms the basis of the offer to the landowner. In other words, they need to provide information sufficient to allow the landowner to understand the offer that's being presented. This is a requirement of Georgia law. Ultimately, if negotiations fail with GDOT, they have the ability to file their condemnation lawsuit. Condemnation is the same as eminent domain. The name of the lawsuit is a condemnation petition. So if they file an eminent domain lawsuit against you, they will file a condemnation petition. They will serve you a copy of that petition to which you can respond. It's important to remember you have 30, as a landowner, you have 30 days to respond to that condemnation petition and file a notice of appeal. contesting the compensation that's offered by GDOT. If you don't respond within 30 days, and if you don't respond within 30 days, properly contesting compensation with a notice of appeal, the case is over, and you ultimately, as the landowner, will receive what GDOT had offered you prior to the lawsuit being initiated. Ultimately, you are entitled to a jury trial over compensation. Not all cases reach juries, but you do have the ability to present your evidence in front of a jury and allow the jury to determine just compensation owed to you. In every case, there are certain aspects of every acquisition. In a partial acquisition, which is a taking of a part of a property and not the entirety of the property, there are three main components to your just compensation case. There's the value of the land itself, and this is usually determined by a price per acre, price per square foot. You're entitled to remainder damage. That is, if there is remainder damage, and you can prove it. Remainder damage is any damage that the acquisition itself or the taking causes to the rest of the property. This is, and for an example of that, on a residential property, for example, if they are taking the front of your house, front of your property, and they're bringing the road much closer to your home, you can potentially make the argument that your property, your house, loses value due to the setback loss or the proximity to the roadway. That's an example of remainder damage. A commercial example would be if they are taking parking from your, taking parking spaces from you, or taking access from you. These types of acquisitions can sometimes lend themselves to remainder damage, such that the remainder property loses value because of what is happening and what they're taking away from the acquisition. Remainder damage can be determined in many different ways. These are just some examples of how they can reveal themselves in partial takings. And then finally, business losses. If you have a business on the subject and the business is being destroyed and cannot be relocated because of the acquisition, because of the project, you could be entitled to any lost business as a consequence of the taking. Again, that's for businesses. And then for total acquisitions, which, as you may imagine, is the taking of the entirety of the property rather than just a portion of the property. The same two of the same components apply in these types of acquisitions as well. The value of the land and business losses, if proven, you can get reimbursement for those or get compensation for the value of the acquisition. But in addition to those two components, and different from partial acquisitions, landowners may be entitled to relocation benefits. If there is a house or an operating business on the property that requires relocation, the landowner or the tenant is entitled to, in residential cases, moving expenses, and if it's the homeowner, they're entitled to a differential payment, which is the difference in value between your home and available homes on the open market that are similar to yours. If you're a tenant, you may be entitled to tenant assistance, basically rent payments to help you get into a new location. If you are a business, you are entitled to moving expenses and then any reestablishment expenses. There is no differential payment for commercial relocation. These, of course, relocation benefits are compensation you are entitled to in addition to the just compensation you're entitled to for the value of the acquisition and the business loss as well. And finally, and this is my last slide, a lot of landowners are curious about how they hire attorneys in these scenarios, and I'm going to provide some examples of how some typical fee arrangements between landowners and attorneys in eminent domain cases. The most common type of arrangement we see is a contingency fee agreement, where the attorney's fee is contingent on how much more the attorney is able to get for the landowner than what is offered by the DOT. Generally, there are no upfront costs, there is no retainer fee. There's no money generally exchanged until the case is resolved, and the attorney's fee comes out at the end. Again, it's contingent, whatever that fee is, contingent on how well the attorney does for the landowner. Other types of agreements between attorneys and clients include hourly or billable rates, where the attorney bills the landowner for work performed. Sometimes that requires a retainer where the landowner provides some amount of money that the attorney then bills against at their typical hourly rate. When the retainer runs out, the attorney may ask for a new retainer or continue to bill at the agreed upon hourly rate. There are a lot of other different types of arrangements between landowners and attorneys, but these are the two most common types of arrangements we see on eminent domain cases. That is the end of my presentation. If you have any questions, feel free to contact me, 470-869-1383. You can also email me at jordan@landownerattorneys.com. Thanks.